Hello, everybody. Welcome to another video on court interpreting. Sorry it took so long to publish these one. People have been chasing me about it. It's a little bit overdue, so apologize for that, but work's been busy, so thankfully. So just in between jobs just now, finding a little bit of time to just quickly record this video. So in the previous video, we talked about summary procedure and the type of jobs that entails in Scotland, and we talked a little bit about the kind of jobs that you might want to think about accepting if you need to court interpreting. And today I wanted to really just very briefly give you an overview of solemn procedure. And solemn procedure, as I explained in the other video, is basically procedure used for more serious offences. So things like human trafficking, rape, murder, culpable homicide, and so on. And the main difference between solemn procedure and summary procedure is, for an outsider, is basically that trials in the solemn procedure are conducted with a jury of 15 people in Scotland. It's different in England, but in Scotland it's 15 people. And in summary procedure, it's not. It's just a judge or a justice of the peace that presides over the case. So from us, from an outside point of view, that's really the main difference. But there's other differences as well apart from that, obviously. And there's a few things that are kind of important for us to be aware of as interpreters, and namely in the types of hearings and types of jobs that you might be offered. So I just wanted to talk a little bit about that today. So so I've got this, I made this beautiful diagram here for you guys, and this basically tries to explain in a kind of visual format what solemn procedure, how solemn procedure works. So the main peculiarity for solemn procedure cases in Scotland is that they've got the stage of the proceedings here called the committal, and there's typically 2 committal hearings. Now, solemn cases can be tried in the sheriff court or in the high court, depending on how serious the case is. If it's at the top end of seriousness, let's call it that way, you would go to the high court. If it's serious but not a murder, maybe an assault to permanent disfigurement, with a racial aggravation, something like that, it might be trialed in the sheriff and jury court, for example. So however, these hearings, they call the committal, and these are basically hearings that happen in the sheriff court building, whether it's a high court or a sheriff court case. So if you ever booked for a committal hearing, just because it's in the sheriff court, don't assume, oh, it's going to be a sheriff and jury case. No, it doesn't mean anything. And really, these hearings are hearings that take place before the case starts as such. So this is a little bit confusing for interpreters to understand, for outsiders to understand, for people that are not legal practitioners to understand. But basically, this is part of the investigative stage of the proceedings. The first hearing is normally called the petition hearing, and it's called that because the accused appears in court on petition. Now, what is the petition? The petition is basically the same as an indictment. And the indictment is the official accusation against the accused. In the summary case, if you remember from the video last time, it's called a summary complaint, or sometimes referred to just simply as complaint or copy complaint. In a solemn case, it's called an indictment. And it can be used as a verb as well. If you'll quite often hear the expression, oh, the person was indicted for the crime of human trafficking, for example. That means that that person was prosecuted under solemn procedure for the case of human trafficking. But before the indictment is created, finalized, the accused appears in court on petition, and basically the petition is a draft indictment. And it can actually be significantly different from what the final indictment will actually be. So it's a draft of the charges that it's anticipated that that person will be prosecuted for. And he appears for the first hearing, and then typically there would be a second one called the full committal, where they decide to fully commit the case to trial or not. And these are technical hearings, in my experience, these most court hearings in Scotland are open to the public with some exceptions, but generally, as a rule of thumb, by default, hearings are open to the public unless for some reason the judge decides to close the court. But this is actually an exception. So committal hearings are not open to the public. They're behind closed doors. And that happens really because, I suppose, the case hasn't started as such. That person hasn't been formally indicted. The indictment doesn't exist yet. That's just a draft version of the charges that he's going to be accused for. So it sounds a bit confusing. Why would that happen? Well, think about serious crimes, for example, a rape case. Someone's just been arrested, he went to the police station, he was interviewed, he goes to court for the petition hearing, and there was some sort of something happened. They know that something happened, but then is it rape or is it just sexual assault? When I say just because it's a less serious offense. It doesn't mean that it's not serious. But compared to rape, is a less serious charge. So they would be looking at, obviously, at the definition of the crimes in the eyes of the law, the evidence available, any further inquiries that might be required to establish what we're actually dealing with here, and then to then decide what is the person actually going to be indicted for. So typically, so there really, this is part of the investigative stage. In my experience, they can be quite technical. They can be quite difficult because they're looking quite often at legal definitions, prior case law, things like that, looking at somewhat at circumstances or the evidence available, inquiries required. But because they're talking quite often about law, from a non-legal expert point of view, for us as interpreters, it can be really difficult to follow, especially if we don't have any context from the background of the case. So normally these are the kind of jobs that would be given to more experienced interpreters, because they can be quite difficult to struggle with. Doesn't always happen. Sometimes you might find yourself first time in court and you're doing a committal hearing. It is what it is. But ideally, these are the kind of jobs that you'd really want a more experienced interpreter to deal with. After the second committal hearing, they would then decide whether to actually take the person to court or not. And if they do, the indictment would then be finalized. And at this point, I've put this line here and said case starts, because it's easier to think about the case actually starting from this point onwards, because before then there's no indictment. So you're not being, you might have been charged at the police station, but you've not, your court case hasn't started as such, because they haven't actually finalized what they're going to indict you for. And as I mentioned before, you can then be prosecuted under in the sheriff and jury court or in the high court, depending on the seriousness of the offences. And the names of the hearings are different, just to make it more interesting. But this is actually quite similar. From then onwards, the sequence of hearings is actually quite similar to summary procedure. If you kind of ignore this committal stage here, this is actually not that dissimilar to summary procedure. So in a sheriff and jury court, you would have a first diet, and then a trial diet and a sentencing diet. In the high court, you'd have a preliminary diet, and then a trial diet, and then a sentencing diet. So what are these diets here? Well, in the first diet, or in the preliminary diet, it's just really a procedural hearing, and it serves the same purpose in solemn procedure as the intermediate diet in summary procedure, more or less, in my experience anyway, where they basically look at the case, the preparation stage of the case, and whether both parties are ready to proceed to trial, to make sure that when the trial starts, then it goes ahead and is not adjourned. High court trials and sheriff and jury court trials are very expensive to run. You've got, jurors being paid loss of earnings. You've got typically lots of witnesses, sometimes professional witnesses, being paid a higher rate of loss of earnings than normal witnesses, and so on. So they're very, very expensive to run. So you really, when that trial calls, you really want it to go ahead. Also, there's not as many, high court judges as there are sheriffs, for example. So there's actually very limited court time to deal with the cases. So you really want to maximize deficiency of trial scheduling. So that's really the main point of these first diets and these preliminary diets, is to, like the intermediate diet, just to make sure that the case is going to go ahead when it calls for trial. So typically you can get multiple of these. So you can get, the first diet can be continued to another date to, if one of the parties or both parties are not ready to proceed to trial, they would adjourn to, to make sure that, maybe in 2 weeks' time or in a month's time, whether you would be ready to proceed to trial. And when both parties are ready to proceed to trial, or when the judge determines that the trial should start, then the trial starts. And then at the end of the trial, if the accused is found guilty, you then go on to a sentencing diet. Now, once again, in the previous video, I explained that in summary procedure, you don't always get a separate sentencing diet. Quite often, the judge just sentences the accused there and then if he's found guilty. In solemn procedure, usually you get a sentencing diet. I can't remember of any case where there wasn't a separate sentencing diet, just because of the nature of the offenses. They're more serious. So invariably, there will be a separate sentencing diet. There'll be a separate hearing just for sentencing. From a newer interpreter's point of view, solemn procedure is more serious. It typically deals with more serious cases. So really, you want to have a few jobs under your belt before you attempt solemn cases. It doesn't always work that way. My very, 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 very first court case many years ago was a sheriff and jury trial, 2-day trial. That's just the nature of it. Sometimes you might find that yourself in that situation, particularly if you speak a rare language. You might not have many opportunities for doing court work, and when there's a case, there's a case, and it is what it is. So sentencing diets, once again, they will be a little bit shorter, although there'll be slightly technical, maybe sentencing statements that the judge will make, which can be quite lengthy, and they can actually be quite tricky to interpret if you don't know some of the terminology. First diet would be a bit easier. Preliminary diet would be a bit easier if you get a choice. Trials, obviously, trials can be very high profile, can be very demanding, can be very lengthy. So not ideal for inexperienced interpreters. But once again, I know of many situations where just because of availability, because of the languages involved, they've had to use less experienced interpreters for rare languages, or maybe more experienced interpreters had already been used in the proceedings so they couldn't be used for the trial. And the judge and the court can, in some cases, accommodate the proceedings to an extent to make sure that the interpreter can carry his or her job efficiently. But typically they would want a more experienced interpreter to make sure that things go smoothly. An interpreter can do proper simultaneous interpreting comfortably, so that they don't need to slow down too much, because otherwise a 3-week trial is going to turn into a 4-week trial, and that's something they do not want. Whereas in a summary trial, which typically lasts, I don't know, which can last half an hour, 45 minutes, if they need to slow down a bit, it's not the end of the world, because it's just going to take an extra 10 or 15 minutes. That's okay. In a solemn case, that's not going to be the case. So that's it. So, but once again, it is what it is, and you might just have to do whatever. But I would say that the hardest hearings in this whole system is really in the committal stage, in my experience. I would really like to hear as well from your experience, if you're a court interpreter and if you've done solemn cases in the past. What do you think? Do you agree? Have you found committal hearings quite challenging, or not? Or do you have any suggestions for new interpreters? So feel free to post some comments, and I hope you liked the video. If you did, give us a thumbs up and like the channel, and thank you very much for watching. Till next time.